There's nothing more powerful than the odor of mendacity.
Text message.
I don't recall any conversation with Detective Thorpe.
I'm saying you can slow it down, but I'm gonna keep asking you these questions. So, do you recall texting or telling Detective Thorpe that so another guy called you and said that those people were just lying?
I don't recall.
My attention, Mr. Weinstein, you have filed a motion to recuse me. You have filed an affidavit consistent with that, pursuant to Uniform Superior Court Rule, I believe 25.2. The court's had an opportunity to read your motion. I've also had an opportunity to take a look at, because this issue comes up a fair bit. Baptiste versus the state, I invite you to take a look at that, and that's from our Court of Appeals, 229 Georgia Appeals 691. Basically, you can't file a motion to recuse for ruling that a trial judge makes, okay? And that's what you're doing in this particular situation. You're saying you don't like what I ruled upon. You're alleging some facts in an affidavit that support that decision. Because if that were the case, then no trial judge would be able to sit through a trial and give adverse rulings. So for the reasons set forth in Baptiste and other cases, I'm going to deny your motion to recuse on its face, okay?
Your Honor, may I just address what you said? I disagree with your characterization that I filed a motion as a result of any ruling.
No. Well, you did in your affidavit. I'm taking in your affidavit as face value, okay? All right,
Yes.
I'm not contesting where you got the information from, at least not yet.
Yes.
But I'm just saying that because it also encompasses that I made a ruling. And as a result of that, if I make a ruling and you don't like it, then every litigant will say, I want to recuse you, Judge Smith or Judge Glanville or Judge whoever, okay? So part and parcel of it is that's why I'm making my ruling in this particular case. Remember, bias. I've got to do something extrajudicial, and you're in your particular, like I would have to say something about you or your clients or anything like that, which I would never do because I'm a steward of this particular process. So I understand what your objection is, or what your statement is in terms of your motion to recuse, and I'm going to deny it.
And I believe, Your Honor, that under Rule 25.3, that you have to cease acting right now.
No, I don't.
And that you can, if I can just finish, and then I promise, if I can just finish this. I believe you have to cease acting. I believe that under 25.3, you have to look at the timeliness of the motion, and you have to look at the sufficiency of the affidavit. I do not believe that you are permitted to just simply deny without taking those steps.
Is that it?
Yes, it is, Your Honor.
Okay. All right. So noted.
Are you denying at this point?
I'm still denying your motion, okay?
Would you grant a certificate of immediate review?
No, sir.
Because
no, sir.
If you grant that certificate, you're always talking about how the appellate court...
No, because if I grant the certificate, it stops the case, okay?
I don't agree with
and I'm not going to do that.
I don't believe it stops the case.
I'm not going to do that.
And if
you can appeal it at the end of the case. If I'm wrong, I'm wrong. Hey, I'll live by it.
But
okay?
aren't you interested in removing the cloud that's hanging over the case right now, Your Honor? If you grant...
Sir, I'd be real careful about what you're pleading at this point in time, what you're stating to the court. As a matter of professional responsibility, remember, we haven't nugged out all of the issues involved in that affidavit. And I would be very careful if I were you, because you have some professional responsibility obligations individually and to this court. And so, I would just leave it at that respectfully. I don't want to get into an argument with you about that, but I would just tell you that, tread lightly, okay, in terms of that at this point.
I understand, Your Honor, and I believe that the certificate of immediate review would be in the interest of the court.
I'm not going to do that. I'm not.
Would you make factual findings regarding?
I am not at this point in time going to, I've denied the motion. Okay.
I believe that's an error, Your Honor.
All right. Okay. Thank you, sir.
Thank you.
All right. Can we call Mr. Copeland now, please?
All right, welcome back Inside the Law. I'm your host, Philip Holloway. Every day I look at the news, maybe Twitter, something on social media, and I see just nonsense going on in the Young Thug trial. And I say to myself, should I do a live stream? Should I do another video? I mean, how many days and in how many ways and in how many times can we say that this trial is just completely off the rails? Thanks to all of you who are here. I see we've started out with 1,200 or so people. Welcome Inside the Law. This is where, in case you're new here, we take you inside the real justice system. We look at it the way it really is in real life, not the way that it's presented to you if you just watch TV or the movies, but the way that it really is. And sometimes we see the good and the bad, and we also see the ugly. Just the other day, for example, speaking of ugly, we saw a lawyer being told he was going to have to spend the Father's Day weekend in jail. Why? Because he had the nerve to call out a judge who had committed an ethics violation. It's called having an ex parte discussion with a party. Ex parte meaning a private, a secret, if you will, one-sided discussion without all the necessary parties being there. And when he called the judge out for meeting with the prosecutor and her witness behind closed doors and allegedly, as we are told, perhaps browbeating the witness into making sure that he testified the way apparently the prosecutor wanted him to testify, the judge threatened to cart him off to jail if this lawyer did not disclose how he found out about the secret meeting.
Not doing that at this point in time. So you'll have a choice to make. All right. Take Mr. Steele into custody, please.
Your Honor, would the court afford me one moment to confer with counsel regarding the appropriate remedy in this type of situation?
Okay. All right.
May I say one thing, Your Honor?
Yes, sir. You certainly may. Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you denied, but I'd like you to deny our motions for mistrial. You denied the other people. I've denied your motion, but I'll certainly take that under advisement, sir.
And of course, we know that later on in the day, of course, right after that, the prosecutor reminded the judge that, look, it might be best to have this lawyer, in the courtroom while he's conducting the trial. Otherwise, you deny the defendant his right to counsel. Then, of course, later in the day, the cavalry arrives and the strike force from the Georgia Association of Criminal Defense Lawyers showed up, led by its president, Ashley Merchant, and attorney Alex Susor. And there were dozens and dozens of other members of the strike force and the GACDL task force that were there in support of Brian Steele, because he did nothing wrong other than being an advocate for his client. And of course, after a brief hearing of sorts, I'm using the term very loosely, it wasn't much of a hearing, but the judge changed his mind a little bit and ordered Brian Steele to spend the next, I guess, 10 weekends in jail for a total of, 20 days in jail for criminal contempt. And then we found out yesterday that the Georgia Supreme Court, of course, has granted him a supersedious bond, an appeal bond. And Judge Glanville, by the way, was so adamant, there's no bond, there's no supersedious, none of this. He's wrong. He was wrong then, and he's wrong now. And I said it at the time. And of course, look what happened. Here's the appeal bond granted by the Supreme Court yesterday. Okay, what happened was the reason it got to the Supreme Court is they filed it with the Court of Appeals, and the Court of Appeals said, well, we think maybe because one of the defendant has a murder charge somewhere in this underlying indictment, since murder cases automatically bypass the Court of Appeals in Georgia, they go straight to the Supreme Court when they go on appeal. So the Court of Appeals transferred the case, the emergency motion for bond, they transferred it over to the Georgia Supreme Court, and the Georgia Supreme Court wasn't entirely sure that that was correct either, the appellate jurisdiction for this contempt. But what the Supreme Court did do that was very practical, because of course the Supreme Court does have the power over all of this appeal. They said, look, we know that a lawyer is basically getting ready to go to jail by the end of the week. So we can't waste time figuring out jurisdiction. We know that we have it here at the Supreme Court. So the Supreme Court said, transfer everything here. We're gonna take the appeal. We're going to issue a writ of certiorari, basically to basically bring the contempt appeal up to the Supreme Court, and they unanimously granted a bond, the supersedious that Judge Glanville was so certain would not be granted. And he said, you don't even qualify for it. But of course, the Supreme Court within 48 hours had done just that, as I predicted right here, and so did many others. And so now Brian Steele, of course, will not have to spend Father's Day in the bug-infested Fulton County Jail. And for that, I think most of us can be thankful. All right. And yesterday, we saw something in this case where there was a motion to recuse Judge Glanville for various things. That was, I'm going to take just a minute and I'm going to play just a little bit more of this for those of you. By the way, there's 2,500 people in here now. Welcome inside the law. I want to make sure you pay attention. I want you to watch this from yesterday, and then we're going to explore in detail what a motion to recuse looks like in Georgia, what this specific motion to recuse looks like, and we're going to decide if the judge was right or if he was wrong. This is just a couple of minutes long, so take a look.
My attention, Mr. Weinstein, you have filed a motion to recuse me. You have filed an affidavit consistent with that, pursuant to Uniform Superior Court Rule, I believe 25.2. The court's had an opportunity to read your motion. I've also had an opportunity to take a look at, because this issue comes up a fair bit, Baptiste versus the state. I'd invite you to take a look at that, and that's from our Court of Appeals, 229 Georgia Appeals 691. Basically, you can't file a motion to recuse for ruling that a trial judge makes, okay? And that's what you're doing in this particular situation. You're saying you don't like what I ruled upon. You're alleging some facts in an affidavit that support that decision. Because if that were the case, then no trial judge would be able to sit through a trial and give adverse rulings. So for the reasons set forth in Baptiste and other cases, I'm going to deny your motion to recuse on its face, okay?
Your Honor, may I just address what you said? I disagree with your characterization that I filed a motion as a result of any ruling.
No. Well, you did in your affidavit. I'm taking in your affidavit as face value, okay? All right, I'm not contesting where you got the information from, at least not yet.
Yes.
But I'm just saying that because it also encompasses that I made a ruling. And as a result of that, if I make a ruling and you don't like it, then every litigant would say, I want to recuse you, Judge Smith or Judge Glanville or Judge whoever. Okay, so part and parcel of it is that's why I'm making my ruling in this particular case. Remember, bias. I've got to do something extrajudicial, and you're in your particular, like I would have to say something about you or your clients or anything like that, which I would never do because I'm a steward of this particular process. So I understand what your objection is, or what your statement is in terms of your motion to recuse, and I'm going to deny it.
And I believe, Your Honor, that under Rule 25.3, that you have to cease acting right now.
No, I don't.
And then if I can just finish, and then I promise, if I can just finish this. I believe you have to cease acting. I believe that under 25.3, you have to look at the timeliness of the motion, and you have to look at the sufficiency of the affidavit. I do not believe that you are permitted to just simply deny without taking those steps.
Is that it?
Yes, it is, Your Honor.
Okay. All right. So noted.
Are you denying at this point?
I'm still denying your motion, okay?
Would you grant a certificate of immediate review?
No, sir.
Because
No, sir.
if you grant that certificate, you're always talking about how the appellate court.
No, because if I grant the certificate, it stops the case, okay?
I don't agree with
And
that.
I'm not going to do
I
that.
don't believe it stops the case.
I'm not going to do that.
And if
You can appeal it at the end of the case. If I'm wrong, I'm wrong. Hey, I'll live by it.
But
Okay?
aren't you interested in removing the cloud that's hanging over the case right now, Your Honor? If you grant
Sir, I'd be real careful about what you're pleading at this point in time, what you're stating to the court. As a matter of professional responsibility, remember, we haven't nugged out all of the issues involved in that affidavit. And I would be very careful if I were you, because you have some professional responsibility obligations individually and to this court. And so, I would just leave it at that respectfully. I don't want to get into an argument with you about that, but I would just tell you that, tread lightly, okay, in terms of that at this point.
I understand, Your Honor, and I believe that the certificate of immediate review would be in the interest of the court.
I'm not going to do that.
Would you make factual findings regarding?
I am not at this point in time going to, I've denied the motion, okay?
I believe that's an error, Your Honor.
All right. Okay. Thank you, sir.
Thank you.
All right. Can we call Mr. Copeland now, please?
Now he's worried about professional responsibility, ethics, and all sorts of things like that. So what I'm going to do, we're going to, in a minute, I'm going to pull up and we're going to look at the actual motion to recuse that was filed. And guess what? I've only skimmed it. I've not gone through it and read it in great detail. So we're going to do that together and we're going to talk about it. And I'll give you my thoughts. And of course, I want you to weigh in with your thoughts on the chat as well. And I'll do my best to answer any questions. But before we do that, I'm going to remove my mug from the screen so that I can show you the rules that apply to recusals of judge in the state of Georgia. So camera's off. Audio should still be here. All right. So what is this? Okay. So this is the duty of a trial judge. And I'm pulling this right from the rules of superior court and the canons of judicial conduct. When a judge is presented with a motion to recuse or disqualify, accompanied by an affidavit, the judge shall, it doesn't say may, it says shall temporarily cease to act upon the merits of the matter and shall immediately determine the timeliness of the motion and the legal sufficiency of the affidavit and make a determination, assuming any of the facts alleged in the affidavit are to be true. So you see, the judge has to basically look at the prima facie claims that are made on the face of the affidavit and assuming they are true, in other words, the judge is not to weigh on whether or not they are true. He's got to assume they are true. And if so, if the facts stated in the allegation are true, whether a recusal would be warranted, okay? And we're going to get to that piece in just a second. If it is found that the motion is timely and the affidavit is sufficient, the recusal would be authorized if some of the facts of the affidavit are true. Another judge shall be assigned to hear the motion. Shall be. The allegations of the motion shall stand denied automatically. What that means is that for the time being, it's not granted. The other judge has to rule on it, right? The trial judge shall not otherwise oppose the motion. I mean, did you see Judge Glanville? He was opposing this motion. In reviewing the motion, the judge shall be guided by the canons 3 of the Code of Judicial Conduct. Well, I happen to have the relevant part of that for you. This is what the judge has to consider. Judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned. Shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned. All right. So you heard the judge say something about it's got to be something extrajudicial, which means outside the courtroom. No, it doesn't. It doesn't. It's right there. If his impartiality can reasonably be questioned. I don't know about you folks, but I think you can make a pretty damn good argument with a straight face that based on what we have seen in this courtroom, in this trial, his impartiality can be questioned. I question it. Do you question it? Tell me in the comments if you question it and why. I got lots of reasons, but the most recent reason is you can't go and have a private, secret conversation in your office with the prosecutor and her witness without telling the defense and without including them. You can't do it. For all the reasons that we've talked about in streams earlier this week, go back and check those out if you missed them. I explain in great detail how ex parte communications with one party, not including all of them, are wrong. They are unethical. They are not allowed. They are, as my guest said the other day, they're like a very bad word. Okay. They are the kinds of things that if you're caught having an ex parte conversation with, and it's not, doesn't fall within any of the very limited excuses, you can lose your job as a judge. The Georgia Judicial Qualifications Commission takes this very seriously. Judges have lost their jobs for much less. So that fact alone, that he did that, to me, in my opinion, calls his impartiality into question. It's 3,740 people. Welcome to this live stream and welcome to anybody who's watching this on replay. Please hit the like button. That helps the algorithm show other people where they can come inside the law to learn about the real justice system. Because what we do is we take cases like this that are in the news and we use them to see if we can learn something about the real justice system. And this trial, unfortunately, we're learning a lot. We're learning a lot about the parts of the justice system that are rarely seen, the ugly underbelly, if you will. All right, let me go ahead and we're going to start looking at this motion to recuse Judge Glanville. Okay. I hope it's big enough for you guys to see it. And we'll just go through it. Okay. It's, let's see. It's not too many pages. We've covered longer documents in here. This is 12 or 13 pages. So let's just go through it. This is the motion to recuse Chief Judge Glanville. And by the way, people are asking me, why is he the chief judge? Well, it rotates. There's a number of judges down there. I don't know how many, maybe 15, 20, and it rotates. And that's my understanding. So that's why he is currently the chief judge, not due to any kind of merit, just because it's his turn. All right. One of the defendants, Demonte Kendrick, by and through his counsel, without waiving any other rights to which he's entitled, files this motion to recuse Chief Judge Ural Glanville from continuing to preside over the present case and request that the present trial be temporarily halted until the present motion is heard by another judge of this superior court consistent with the uniform rules. And he cites some case law. It's vital to the functioning of the courts that the public believe and have the absolute integrity in the impartiality of judges. And that's true. That is absolutely true. This case involves 65-count RICO indictment against 28 individuals, and it goes on with the procedural history, jury selection having begun in January 2023, and here we are in June of 2024, and we're not even halfway through. Mr. Kendrick having been denied bond and incarcerated for over 2 years. A central figure in the state's case is Kenneth Copeland. Kenneth Copeland. My highlighter's going crazy. This is the witness who, as you know, basically was held in contempt, and he was thrown in jail because he refused to testify. This is, let's see, this was Kenneth Copeland.
Text message.
I don't recall any conversation with Detective Thorpe.
I'm saying you can slow it down, but I'm gonna keep asking you these questions. So, do you recall texting or telling Detective Thorpe that so another guy called you and said that those people were just lying?
I don't recall.
Look, I mean, if it wasn't so ridiculous, it would be comical. But that's Kenneth Copeland, folks. He was thrown in jail because he was given immunity by the prosecutors for anything that he testified to that might violate state law, but it didn't cover because it's just the local DA. It's not the federal government. His immunity did not cover any federal crimes that he might take the stand and confess to. And so he at first invoked his Fifth Amendment rights, as his lawyer rightfully told him to, because his immunity grant wasn't broad enough, and the judge threw him in jail simply because he invoked his Fifth Amendment right. But we could do another show about that. Anyway, Kenneth Copeland is quite the figure here. He was sworn in. He began testifying. And despite being warned by Chief Judge Glanville that incarceration may result, he refused to testify that day. Okay. He was incarcerated by Judge Glanville, said that all parties would return to court Monday. On Monday, June the 10th, okay, it was Monday of this week, all defense counsel, this is important, all defense counsel were present in the courthouse around 8:30. They were admitted into courtroom 1C. They were seated by 9. The defense counsel waited and waited. Between 11:30 and 11 a.m., Chief Judge Glanville took the bench and announced that Copeland was prepared to testify. How'd you know that, Judge? Brian Steele, counsel for the defendant, Mr. Williams, who is also known as Young Thug, the Atlanta rapper, inquired with the court as to the nature of the delay and what had occurred. Judge Glanville refused the inquiry. At that time, unknown to any member of the defense counsel waiting during the waiting period in the morning, upon information and belief, and this is what lawyers say, it basically says, I have a good faith belief for stating this. So upon information and belief, an ex parte meeting was held in Judge Glanville's chambers. All right, there it is, ex parte. And it says Judge Glanville Judge Glanville was present, Assistant DA Love, Assistant DA Hilton, and other members of the Fulton County DA's office, that's Fannie Willis' office, deputy sheriffs, and the sworn witness, Kenneth Copeland, and Kenneth Copeland's attorney. No member of the defense counsel was present at the ex parte meeting, despite the subject matter of the meeting being a critical phase of the trial. Again, for reasons that I went over in other videos, the ex parte, the one-sided conversation with this judge was unlawful. It was unlawful. It was improper. It was a violation of the canons of judicial conduct. And the Judicial Qualifications Commission, it's my understanding here in Georgia, they have the power to police these things. They are already involved in looking into this. This is the kind of thing that could that meeting alone could cost him his career. So the lawyers rightfully are complaining about this, but they go on here and they say, upon information and belief, neither Judge Glanville nor any member of the court staff made any member of the defense counsel aware of the ex parte meeting, either before the ex parte meeting was held, during it, or after. All right. The complainant briefly testified prior to a lunch recess. One or more of the defense counsels were later made aware. This is where it gets really interesting, guys. One or more of the defense counsel were later made aware of the ex parte meeting with sworn witness Copeland, and they were made aware of at least some of the content and subject matter. And see, this is what the judge is. He's like Captain Queeg looking for, he's obsessed with his strawberries. For those of you who are familiar with the reference from the Cane Mutiny, he's obsessed with finding out who told on him. Okay. Who dimed him out? Who told these nasty defense lawyers that I'm back here holding this illegal ex parte? All right. So they learned, it says, upon information and belief, the following events occurred. I don't know why my computer is highlighting this in such a crazy way, but anyway, bear with me. The following events occurred. It says Copeland announced that he would invoke his Fifth Amendment rights and not testify. Copeland stated he would sit in jail for 2 years rather than testify. Chief Judge Glanville informed Copeland that he would keep him incarcerated until additional defendants were tried, not just the 6 defendants that are currently on trial. Remember, there's a lot more of these defendants that have not gone to trial yet. They were severed for various reasons. So according to this allegation here, Glanville is threatening this witness that I'm going to hold you in jail, I guess indefinitely, because it could be decades before all these defendants are tried. Not just, and he's threatening him, saying, look, if you don't get out there and testify, I'm going to hold you in jail indefinitely. Indefinitely. This is how broad this judge thinks his contempt power is. And the fact that he's being accused of this alone is reason enough for him to hit the pause button on this trial, let another judge take over the trial, and let all this stuff be sorted out. Because if these allegations are true, that is absolutely stunning. That's intimidating a witness. He's basically accusing the judge. This lawyer is accusing the judge of being a part of the prosecution team. That's what this is. Upon information and belief, ADA Love or Hilton informed Copeland that there were over a dozen defendants left to try. So the judge is saying, I'll keep you here till they're all tried. And the prosecutor is saying, that's right. We got at least 12 more of them to try. Upon information and belief, following the above coercive actions by Judge Glanville, in conjunction with one or more attorneys from the Fulton County DA's office and the sworn witness, Copeland, he stated after that, he said, okay, I'll testify. I give in. I'll testify. Says Judge Glanville also presented Copeland with a printout of Georgia's perjury statute and the false statement statute. So the judge, according to these allegations, the judge is saying, look, here's the law that says if you don't testify truthfully, they can prosecute you, and then Copeland stated to the assistant DA Hilton that if called, he would simply lie on the stand. Upon information and belief, in response to that, Copeland, ADA Hilton, that she would not prosecute Copeland if he were to lie on the stand. All right. So it goes on to say, Copeland also stated to ADA Hilton that he would testify that he killed Donovan Thomas. Okay. So the killer of Donovan Thomas is one of the big deals in this trial, but for purposes of our discussion, we'll just leave it at that. But Copeland is saying he's back there in chambers with the judge and everybody, saying that he would testify he killed Donovan Thomas. And after that, Hilton said that, all right, if you testify that you killed Donovan Thomas, she's going to prosecute him for perjury if he testified to that. In other words, if you don't testify the way I want you to, I'm going to prosecute you for perjury under that statute that the judge just pulled out and showed you. Unbelievable. If true, these allegations are enough to get all of these people fired, disbarred, potentially prosecuted. This is third world, banana republic, kangaroo court craziness, guys, if this stuff is true. And this is what the lawyers are claiming in their motion to recuse the judge. Okay. So remember, back to it's not that you have to prove these. If you raise these issues and assume that they're true, does this show that the judge could reasonably be believed to be impartial? And the answer has to be yes. So that means that the motion to recuse Judge Glanville should have gone to another judge. But anyway, they go on to say, during court on the afternoon of the 10th, when one or more of the allegations were presented to the court by Attorney Steele, Judge Glanville denied that one or more of the events related to him were accurate. He didn't deny, of course, as we recall, the ex parte communication, but he denied that at least some of those may not be accurate. They point out here in the motion that the judge must cease to act and make an immediate determination. Okay. Well, where are they getting that from? It says here, this is the uniform rules of the Superior Court. When a judge is presented with a motion to recuse, disqualify, accompanied by the affidavit, the judge shall temporarily cease to act on the merits of the matter. So they're not making this up, folks. The lawyers are dead right on what they're claiming here in this motion, what the law requires. They're dead right. All right. And it says that, all right, you go on to say, when a trial judge is presented with a recusal motion or accompanying affidavit, the judge must temporarily cease to act on the merits and determine immediately whether the motion is timely. And by that, look, once a lawyer has information that a judge is, that would call into question the judge's impartiality, he's only got 5 days. He or she only has 5 days to raise this. And so that's what they mean by timely. All right. And so if the affidavit sets forth facts that, if proved to be true, would warrant the assigned judge's recusal. So look, assuming that any of those facts that are alleged were true, would they warrant recusal? Hell yeah, they would. There's no question that they would. So you've got to look at it objectively and say, look, without deciding if these things are in fact true, assuming they are true, would they warrant recusal? And if the answer is yes, then he's got to send it to another judge to fully flesh it out. The recusal is being timely submitted. Uniform Rule 25 governs motions for recusal. It's here, like I just said, it's got to be done not later than 5 days after the affiant learns of the alleged grounds of disqualification. So they have an obligation, folks, under the law to do this. They've got to raise this issue within 5 days. And the judge is mad that they're raising the issue. Instead, the only thing he's worried about is who is the leaker. That's all he cares about, is finding out who is the leaker, who let the cat out of the bag. All right. Given that the most recent incident demanding recusal just occurred on June 10th, a 2-day period elapsing from the incident is good cause. So it's only been a few days. So it's timely. And the present motion includes a sufficient affidavit. In an accompanying affidavit by Douglas Weinstein, Exhibit 1, with evidence for recusal, has been filed and now presented, which fully asserts facts upon which this motion is founded. A review of the Weinstein affidavit clearly states the facts and the reasons. It's specific with respect to time, place, persons, and circumstances. The particulars of the Weinstein affidavit are provided above and need not be presented again here in detail, but lays out the alleged actions of Chief Judge Glanville in connection with the state with respect to sworn witness Copeland that took place in the chambers of Judge Glanville, June 10th, 2024. Recusal is warranted. Okay, let's see why they're saying that recusal is warranted. The details learned, let's see. The facts alleged in the Weinstein affidavit must be assumed to be true. All right, that's what we just covered. Must be assumed to be true when deciding whether recusal would be warranted. The details learned by Weinstein detail the holding of an improper ex parte hearing conducted with sworn witness Copeland, which violated the constitutional and statutory rights of Kendrick, including the right to due process and a fair trial. And what do they mean by that? Look, if a witness is, and I'll come back to this in a second. If a witness is meeting with the judge and with prosecutors back in the judge's office, anything that witness says is grounds for cross-examination. In other words, when you cross-examine a witness, you're looking at things that may cause the witness to be biased, things that may reflect bias. And look, do you think that a witness might have some motive to testify maybe more in favor for the prosecutor if they've just left a meeting where the judge is threatening to hold them in jail indefinitely if they didn't testify the way the prosecutor wanted them to? And that's kind of what they're saying here is happening. And that would be a thing that you would want to cross-examine that witness on in front of the jury. But by denying them access to the meeting and without denying, and of course, denying them later transcripts of it, you're denying these lawyers their right to cross-examine the witnesses called against their clients. It's called the right of confrontation. It's in the Constitution. It's the confrontation clause. You got a right to confront your accusers, and that means you've got a right to cross-examine with the assistance of counsel, the effective assistance of. There's so many constitutional rights at play. You got the Fifth Amendment, your Sixth Amendment, your due process rights. All these rights are being implicated here by this alleged judicial and prosecutorial misconduct. All right, let's get back into this before I get carried away. The ex parte hearing with sworn witness Copeland was in violation of at least section 2.9 of the Georgia Code of Judicial Conduct. Okay, we went through that, but let's see. I think they give it to us right here. So let's take another look for those of you who may have missed the other day. This is the relevant part. Judges shall not permit. This highlighter is going crazy. Okay, judges shall not permit or consider ex parte communications or consider other communications made to them outside the presence of the parties or their lawyers concerning a pending proceeding or impending matter, subject to the following exceptions. And I won't go through all of them, but none of them apply. For example, scheduling, administrative purposes, and just things that don't apply. You can go and look at them yourself. Judges may obtain the advice, for example, of disinterested experts on the applicable law, things of that nature, but it doesn't include meeting with the prosecutor and their star witness. Rule 211 of the Revised Code of Judicial Conduct says generally that judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned, followed by a non-exclusive list of specific situations in which recusal is required. The standard is an objective one, okay? Remember, at the beginning of this stream, I shared with you guys this right here, okay? Judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned. That is an objective standard, meaning if you look at it sort of in the not subjectively, but as an unbiased, impartial third party objectively looking down on it. If you look at these allegations, would the judge's impartiality reasonably be questioned? So that's what they're talking about. All right. Okay, I'm back. Here we go. The standard is an objective one. The facts must be considered from the perspective of a reasonable person rather than from the perspective of interested parties or their lawyers. Okay. Judge Glanville should not have coerced witness Copeland to testify. Well, that sounds obviously true to me. A trial judge, and they cite some case law here, a trial judge should not attempt to intimidate a witness to testify on behalf of the state. That seems like you don't need to cite case law, but nevertheless, there you have some. It goes all the way back to 1938, in this case, Benson versus State. That's just how obvious it is. More case law, it says, and they point out here, defendants were not provided notice of the hearing before, during, and after. Defendants should have been afforded the opportunity to attend any hearing with a sworn witness. That means somebody who's already under oath and in the process of testifying, like Copeland. They should have had an opportunity to be there. They're saying he's being coerced to testify, coerced by the judge and the prosecutors. The only logical conclusion, according to this motion, to be drawn by the willful exclusion of all defense counsel the willful exclusion of all defense counsel from the meeting among Judge Glanville, the state, and sworn witness Copeland was to harass and intimidate the witness into testifying. Okay. Given that the facts as alleged must be assumed for purposes of evaluating this motion to be true, the Weinstein affidavit is sufficient and recusal would be authorized under the facts. Another judge should hear this motion to recuse. And for the reasons that I pointed out at the beginning, you know that that is the law in this case. That's the law in the state. So that, of course, is accurate and true in all respects. Wherefore, Mr. Kendrick respects that the present motion meets all the requirements for recusal. This motion should be assigned to another judge for consideration. In the alternative, should this court deny the requested relief in this motion, Mr. Kendrick requests that the court make specific factual findings and submits that Glanville should voluntarily recuse himself, which he could do, and avoid all this. Should the court take neither of the above actions, Kendrick moves for a mistrial due to the ongoing bias of the court as evidenced by the Weinstein affidavit, and on the basis that Mr. Kendrick is not receiving a fair trial under the Constitution. All right, let's move on down. Let's see what the affidavit says. We'll get past the certificate of service. Okay, here's the affidavit. All right, before we move into the affidavit, we got almost 5,000 people in here. Thank you so much for everyone who is here. Please hit that like button. It helps with the algorithm. It helps others who want to learn about the real justice system find this channel where they can join us as well inside the law. Thank you also to those of you who have asked questions, and thank you for the super chats. Astral Guardian points out, even as a normie, I guess you mean by that a non-lawyer maybe, you can tell this judge is veiledly telling this other attorney that he really should not push back. Basically, that's right. He's basically saying you should not push back. How much of the back and forth between the judge and the attorneys is personal as opposed to actual bit? You know what? That's a great question. I feel like a lot of it is personal at this point. I don't feel it so much from the lawyers. I feel that the lawyers are doing their job, but I feel the judge is taking this very, very personally. I feel like he's taking it very personally. There's a video that I've got on that. I'll get back to it in a little bit, but I've got some video that shows the judge that it looks like he's really personally invested in. Well, in fact, let's see. I might be able to just get into that right now. It won't take but just a minute. Let's see, before we get into the Weinstein affidavit, let's see if we believe that the judge is really personally invested in this. Just about a minute and a half.
And I know that they did know that he was going to take the fifth because I heard it said outside right before I walked into court. I even said, the officer.
Then why didn't you, as an officer of the court, tell me before we took his testimony?
I told Mr. Steele.
No. Why didn't you, as an officer of this court, tell me?
Well, then that's my.
I got a problem with you now.
Well, that's fine. I mean.
I got a problem with you now.
Well.
I would suggest you don't say any more.
I've already said it.
I know that, sir. And the problem is you should have told me. If that were your case, then you've just made an argument we didn't even need to have, because I could have certainly asked him based upon your proffer. Now you want to have it both ways. You can't do that.
Your Honor, I thought the state knew that. And
that's not what the point is. The point is, you as an advocate, is you should have told me. Both sides have an equal responsibility under the rules of professional responsibility.
Okay.
He's mad. He's mad. He's angry. I mean, I think it's personal. I mean, that's just my opinion. I welcome yours, but to me, it seems personal. All right. Let's get back into this affidavit. Weinstein affidavit personally appeared. Okay. Sworn witness Copeland this is some of the same things that were included in the motion. Copeland being held in contempt. Judge Glanville presiding over the case. Glanville instructed the witnesses and parties on June 7th that Copeland would be jailed and returned to court. That's true. Defense counsel present in the courthouse. These were recited in the motion itself. This is the this is the affidavit that must accompany. It's required to be accompanied to accompany the motion to recuse. Otherwise, the motion to recuse is facially invalid. It's the same thing between 11 and 11:30. Judge Glanville took the bench, announced Copeland was prepared to testify. Okay, so far it's the same things that we've just been over. We've got the threats. I'm just looking through to see if there's anything different in here than what we had in the actual substance of the affidavit. And it looks like, nope, it looks like that's it. So we've got the entirety of the affidavit here has been included in the motion to recuse. All right, so that's it. So that's the motion to recuse. And for those of you who are perhaps just joining us, this was what happened in court. It's worth looking at again. This is what happened in court when the judge was presented with this motion.
My attention, Mr. Weinstein, you have filed a motion to recuse me. You have filed an affidavit consistent with that, pursuant to Uniform Superior Court Rule, I believe 25.2. The court's had an opportunity to read your motion. I've also had an opportunity to take a look at, because this issue comes up a fair bit, Baptiste versus the state. I invite you to take a look at that, and that's from our Court of Appeals, 229 Georgia Appeals 691. Basically, you can't file a motion to recuse for ruling that a trial judge makes, okay? And that's what you're doing in this particular situation. You're saying you don't like what I ruled upon. You're alleging some facts in an affidavit that support that decision. Because if that were the case, then no trial judge would be able to sit through a trial and give adverse rulings. So for the reasons set forth in Baptiste and other cases, I'm going to deny your motion to recuse on its face, okay?
Your Honor, may I just address what you said? I disagree with your characterization that I filed a motion as a result of any ruling.
No. Well, you did in your affidavit. I'm taking in your affidavit as face value, okay? All right? I'm not contesting where you got the information from, at least not yet.
Yes.
But I'm just saying that because it also encompasses that I made a ruling. And as a result of that, if I make a ruling and you don't like it, then every litigant will say, I want to recuse you, Judge Smith or Judge Glanville or Judge whoever, okay? So part and parcel of it is that's why I'm making my ruling in this particular case. Remember, bias. I've got to do something extrajudicial, and you're in your particular, like I would have to say something about you or your clients or anything like that, which I would never do because I'm a steward of this particular process. So I understand what your objection is, or what your statement is in terms of your motion to recuse, and I'm going to deny it.
And I believe, Your Honor, that under Rule 25.3, that you have to cease acting right now.
No, I don't.
And that you can, if I can just finish, and then I promise, if I can just finish this. I believe you have to cease acting. I believe that under 25.3, you have to look at the timeliness of the motion, and you have to look at the sufficiency of the affidavit. I do not believe that you are permitted to just simply deny without taking those steps.
Is that it?
Yes, it is, Your Honor.
Okay. All right. So noted.
Are you denying at this point?
I'm still denying your motion, okay?
Would you grant a certificate of immediate review?
No, sir.
Because
no, sir.
If you grant that certificate, you're always talking about how the appellate court.
No, because if I grant the certificate, it stops the case, okay?
I don't agree with
and I'm not going to do that.
I don't believe it stops the case.
I'm not going to do that.
And if
you can appeal it at the end of the case. If I'm wrong, I'm wrong. Hey, I'll live by it.
But
okay?
aren't you interested in removing the cloud that's hanging over the case right now, Your Honor? If you
Sir, I'd be real careful about what you're pleading at this point in time, what you're stating to the court. As a matter of professional responsibility, remember, we haven't nugged out all of the issues involved in that affidavit. And I would be very careful if I were you, because you have some professional responsibility obligations individually and to this court. And so I would just leave it at that respectfully. I don't want to get into an argument with you about that, but I would just tell you that tread lightly, okay, in terms of that at this point.
I understand, Your Honor, and I believe that the certificate of immediate review would be in the interest of the court.
I'm not going to do that.
Would you make factual findings regarding?
I am not at this point in time going to, I've denied the motion, okay?
I believe that's an error, Your Honor.
All right. Okay. Thank you, sir.
Thank you.
All right. Can we call Mr. Copeland now, please?
All right. So that was the hearing, if you will. And what should have happened? The judge should have immediately stopped acting on the case itself, should have reviewed that motion, reviewed the accompanying affidavit, and for purposes of that review, assume that the judge should have assumed that the factual allegations alleged in the affidavit were true, and if so, asked himself the question. The question being, would that call into question his impartiality? Okay, and the answer has to be yes. Okay. So, and then automatically the rules require at that point that the case be sent, the motion, not the case, but the motion to recuse go to another judge. Because it's kind of like grading your own papers. Back when I was in grade school, we would have to pass our paper to the person across the aisle from us, and you trade papers and you grade the quiz or whatever. So you didn't wind up grading your own paper. Well, this is what that was. This was the judge grading his own paper. He was passing upon the wrongfulness or not wrongfulness of his own actions. Okay. And this is all has nothing to do with, this issue here about recusal, it's related to his improper ex parte, which can cost him his job, I think, at some point. But this is about him not continuing to serve as the trial judge in this case. I don't know why he can't just say, look, because if it was me, whether I did something wrong or not, but if these kind of allegations were made, I would say, all right, look, I'm going to go ahead and have my colleague, the judge so-and-so down the hall, who's got the next 3 years free, apparently, I'm going to have that judge take over the trial of this case. And I'm going to go ahead and recuse myself, because at this point, the hole is getting dug deeper and deeper and deeper, almost by the day. I'm sure that when we finish this live stream and I check in on the trial to see what's been going on the last few hours, I'll find something else that's just craziness. And it's every day. I'd like to find out, maybe some of you know, and if you're in the chat, feel free to tell me. And by the way, 5,000 people in here now, please hit that like button. It really helps the algorithm. But also for those of you who might be new here, I'll tell you this, I go back after these live streams and I will go back and do my best to look at the comments that are in the chat that I miss, because I can't see them all. It's moving pretty fast. And tell me in the chat, if you know this, how many people, since the jury selection and pretrial motions and everything began in this case, back when there were 20-something defendants all in that courtroom, how many lawyers, prospective jurors were threatened with or actually held in contempt? There was one day I remember that judge didn't like something that one of the lawyers did or said, and he ordered him. He said, I'm going to find you in contempt, and as your punishment, I'm ordering you to buy lunch for all of your other colleagues. And then there was I think it was a prospective juror that he made write a long research paper. It was like a juror who was late or didn't make it to court or something. I'm doing this by memory, so I'm sure you'll correct me if I'm wrong. But he made him write like this long, like an essay or like a research paper with publishable quality, with annotations and citations and all this on being on time for jury selection or something along those lines. It's just one of these situations where I've known there's some judges, many judges in fact, that I've known for 20 or more years, and at no point in time have I ever seen any of those multitude of judges threaten people with contempt, not once. But you watch this trial and you see it almost every 10 minutes. You saw it in that last clip. You be very careful with your words now. That's or I'll do to you what I did to Mr. Steele. I guess this happened yesterday before Judge Glanville knew that the Supreme Court had smacked him down. They granted Steele the bond. They put his order of contempt on stay. Oh, and by the way, his contempt citation was lengthy. It was wordy. It had all kinds of case citations and all this stuff. And if you read it, you would believe, oh, that makes a lot of sense. He cites case law. It must be accurate. And he told Ashley Merchant, and even before Ashley got there, he told Brian Steele, there's no contempt. I mean, there's no appeal. There's no supersedious bond and all that stuff. And of course, yes, there's an appeal. They're going to hear it. The Supreme Court's going to hear it. And a unanimous Supreme Court granted the bond. But he was so certain that he was right when in fact he was wrong. I mean, it's just unbelievable. Unbelievable. I've got so much video on this. I don't know. Here's part of the interaction between Brian Steele and the judge that led up to the contempt.
Supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court,
okay.
Or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26.
That was when Brian Steele was making his initial objection to the ex parte. And I've known Brian Steele for at least 25 years. I met him, first time I met him was when I was a relatively newbie prosecutor in a nearby county. And Brian Steele was on the other side as defense counsel. Gentleman, there's no more of a gentlemanly lawyer you will ever meet than Brian Steele. He is wicked smart. He's very cerebral. He's got, he has won some major appellate victories and trial victories, I should add. But at that point in time, he was kind of known for his appellate victories. He hit me with so many unique, thinking outside the box pretrial motions, wore me down. I mean, just literally, I got to hand it to him. He did a great job and he was so nice about it the whole way. Just wore me down with paper, with pretrial motions, but he's not going to come to this thing unprepared, and he's not going to be unprofessional either. And he always refers to courts as this honorable court, honorable court, honorable court, honorable court. But in that clip, you heard him say, this honorable court, and then he corrected himself. Let me correct myself. And then he just said this court. And for those of us who know Brian Steele, to see him drop the word honorable, that was his way of telling the judge without raising his voice that he's pissed. He's really, really pissed off. And he had every right to be. I think he was doing a fantastic job. I want to see if we've got any questions that we can answer. First one I see is Winnie is asking, when will I get Ashley Merchant back? It is said that Brian Steele will not go to jail since the motion is pending by. Well, he's not going to jail because Ashley's emergency motion for supersedious bond was granted by the Georgia Supreme Court. So they issued a stay of the contempt order. If you're asking me when I'm going to get Ashley Merchant back, soon, I hope. Ashley and I work together a lot professionally on certain cases. And so we have a good bit of interaction with one another. And I can tell you, there's no lawyer I know of, except for maybe Brian Steele and those in that courtroom right now, that are busier than she is with lots of appeals and some things going on. And, but I will do my best to get her back. Now that she's representing Brian Steele in this case, she may not be able to come on and talk about it, but there's going to be other things inside the law where, if I can get her available, if she has time, I'd love to have her back. She's, of course, welcome here anytime, and she knows that. I do know that she watches Inside the Law, and she sees your comments, and she appreciates them. All right. Very good point. Good question. All right. So, yeah, so she's an absolute legal warrior. That is absolutely true. A lot of people are pointing out that he needs to be removed from the bench. And so that is that. I'm certain that the Judicial Qualifications Commission, which is the entity, the state agency in Georgia that deals with judicial discipline. They have lots of authority to take action. They have some emergency authority to move really, really quickly. I don't know what they're going to do. I don't pretend to have any inside knowledge. They're a small agency, but they're nimble. They're able to turn on a dime, and I do have reason to believe that they are very actively interested in these proceedings, as we all are. So we shall just have to wait and see what, if anything, they do. All right. Let's see. Another question. If you preface your comment like this with the word question, it makes it easier for me to see. I don't have a moderator in here to star questions for me like sometimes I do. So that helps me identify questions. For example, this one: when will he be removed? When will there be? I don't know. It could be soon. It could be a couple of months from now. It could be after this trial's over. We don't know. It's going to be up to the Judicial Qualifications Commission to determine what they're going to do. Can the judge get time for misconduct? I guess you mean jail time. No, he's not going to go to jail unless he commits a crime, in which case somebody'd have to prosecute him. But for this type of violation of the judicial canons of judicial conduct, if he's deemed to have violated one, that would be the penalty could be up to and including removal from office. But a lot of times what will happen is when the JQC comes sniffing around, these judges, they'll read the handwriting on the wall and they'll go ahead and retire, go spend some time with their family or whatever. People are asking, are we in mistrial territory? Yeah, I think we are well inside mistrial territory. I think we were in mistrial territory weeks and weeks and weeks ago. So this is part of my problem with these giant racketeering cases like this one and it's Fannie Willis that did it. She's the one that created this indictment that is so big that it takes years and years and years. And the longer a case goes on, the more likely it is that there's going to be something that the judge does to commit reversible error. Okay. And this case has been going on for a long time. The longer a case goes on, the more rulings the judge makes. And the more rulings the judge makes, the more likely he makes erroneous rulings. Not all erroneous rulings are grounds for mistrial or reversal, but some of them are. So the more rulings you have to make, the more likely it is that the case could potentially be reversed. Can these lawyers go over this judge's? He is the lead judge. The question is, can they go over his head basically to the lead judge? He's the chief judge in the Atlanta circuit. And even if he weren't the chief judge, the only way to go over a judge's head is to the appeals court. And there's no way to get to the Court of Appeals in the middle of a trial, if not really. However, the Supreme Court does have the contempt issue now, and so you might get some ruling before this trial's over on the merits of the contempt. So that's kind of like going over his head, but it's not. There's nobody that can force him off this trial unless unless he refers a motion to recuse over to another judge. And the fact that he didn't, that's probably reversible error right there. Okay, so no matter what happens, if there's any convictions here, they're not going to stick. But the problem is it's going to be years and years and years before we get any kind of ruling, because it's going to take years for the transcripts and for the record to be put together to be transmitted up to the appellate courts. Okay, so let's see. I'm trying to catch this before the thing is scrolling so fast, it's hard for me to catch it. A lot of JAG officers and judges are cringing hearing about this case. Yeah, well, you say that because the judge is a former Army JAG officer. In fact, he was a general and served with distinction. I had a conversation this morning with a judge in another jurisdiction, and we were in his office, but we weren't having an ex parte, I promise. We were talking just as friends, talking about current events. And it happens to be a judge who watches this, watches inside the law. And so then another lawyer came in, and then judge's assistant come. And so we were all sort of shooting the breeze. And this was one of the things that was being discussed. And I can just tell you across the board, the legal community around here is just flabbergasted. I mean, it's like, we are just like, how in the world did we get in this judicial la la land here? I mean, it's just absolutely bananas. We're just flummoxed. We don't know how this is even real life. It's just that bad. It's just that bad. All right, guys, look, we've been at it an hour and 10 minutes, and I don't know what else I can say. I don't know what else I can say about this motion to recuse the judge, other than he was wrong. He should have sent it to another judge. He should have let another judge have a hearing on it and basically paused the entire trial. And by the way, you heard the lawyer ask for what's called a certificate of immediate review. Okay, well, we last saw that creature, the certificate of immediate review. We saw it in the Trump RICO case, where Ashley Merchant got a certificate of immediate review when Judge McAfee made a lot of factual findings that Fani Willis had done a lot of wrong things, but he didn't go so far as to remove Fani Willis. So Judge McAfee, issued a certificate of immediate review, which allowed for the pre-trial appeal of a judge's ruling. Okay. And so that's what this lawyer was asking for. And if the trial judge doesn't grant the certificate of immediate review, it's over. You don't get to appeal. So he should have at least granted that. But even before that, he should have sent the whole issue of recusal to another judge. And I feel confident there's some good judges in Fulton County. They're not all questionable, but in any event, I feel confident there's a really good chance another judge would have removed him had he sent it to the right place. I want to, let's see, any other good questions before, I just don't know what else I can say about the motion to recuse, other than it should have obviously been granted. Can someone sue to get him disbarred? No, that's not done with a lawsuit. The State Bar of Georgia is the entity that is in charge of attorney licensing. And so they would have to someone would have to file a bar complaint, and they would have to evaluate that. And, it takes a very, very long time. It's not something that somebody could do to do by lawsuit. So this is an interesting point. Suggest one of the Roadcast units mismatched audio. I don't know if I have mismatched audio levels. If I do, I don't know it. I am not in my regular place today. I'm at my office. This is my backup sort of set for doing these live streams. But thanks for that suggestion. And thanks, by the way, for the super chat. Always appreciated. All right, guys, look, well, another good question. I was about to call it a day, but I can answer a few more questions. If there's a mistrial, does that mean the case will be retrialed? This is a great question. Or is that double jeopardy? If there's a mistrial based on this ex parte with the judge and the prosecutor, it's over. Double jeopardy attaches. It can't be retried because it's not the defendant's fault. It's the fault of the prosecutor and the judge. So it would be over. It would absolutely be over. And see, this is part of why it doesn't make sense that, the judge is obviously personally invested in it. From what we showed earlier, I think he's emotionally invested in it as well. So that keeps him from doing what I think is the right thing, granting the motion, letting another judge deal with recusal, perhaps granting the mistrial, for heaven's sake, and let's just be done with it, because at this point, it's just a waste of time and resources and money, and it's a further violation of these people's rights. Thank you, by the way, to those of you who have joined as members and who have supported the channel through super chats. And by the way, if you like this content, don't forget to get the like button, subscribe. I'm trying to get over 40,000 subscribers now, but there's also links in all of the show descriptions of other ways to support the channel inside the law. And I appreciate those of you who have or who may do that in the future. Thank you very much. I'm going to come back to this trial. I'm not going away from this trial. I'm going to be watching it and watching it very closely. I've got to do something on some of the other legal news, but this trial is so compelling and there's so much to learn from it. That's why we've been hitting it really hard this week, and we're going to continue to do that. So I want to ask all of you to keep up with the channel. You can follow me on social media on X. I'm pretty active there. I engage with the channel as well through on YouTube in the community section, for example, on locals inside the law. I do my best to communicate with folks, and I will tell you most of the time when I've got something planned. But there's so many things that are coming up here on this case, things that will happen. We might have some spontaneous stuff. I'm going to be traveling some towards the end of this month. And so I want to make sure we cover as much of this trial as we possibly can over the next several days or week or 10 days. But even if I'm traveling, I'm not going to forget about what's going on. We may have some special short editions of Inside the Law later on this month. Thank you all very much for being here. And always remember that it's important.
There's nothing more powerful than the odor of mendacity.
Important to remember that, because if you can live your life without spreading the odor of mendacity, then your life will have been a success. Thank you very much for joining us, and I'll see you back here next time inside the law.